Minutes ago, we held a hearing before Judge McGrath. It was our motion to dismiss 3,042 cases, outstanding warrants for where the charge was possession of marijuana as a misdemeanor or as a violation. The judge granted that motion. Those cases are now dismissed. And I believe that's when our records started. Because historically we see that enforcement of the marijuana laws has disproportionately affected men and women of color. I believe 86% of individuals who have been prosecuted in 2017 for these offenses were in fact men and women of color. So if, for whatever reason, a police officer did through inadvertence or non-awareness of what the court said today, pull someone in on one of these warrants, what would happen is simply following our policy today. And, we would dismiss the case without the accused person having to do anything. But I think you can drive down the West Side Highway at 75 miles an hour and you'll get a ticket to be paid by mail to court. But if you are arrested, if you are found smoking a marijuana cigarette, you can be arrested, put in cuffs, and held in jail for 24 hours. The offense does not, in our opinion, justify that level of enforcement, and we are trying to even out racial disparity and rationalize and right-size our criminal justice efforts.
What should we tell people if they think there is? Contact your office,
Any one of these 3,042 people are living. They may have forgotten about it, but they are living with the peril of being put through the system for almost no reason because of this warrant hanging over their head.
This is significant to changing the lives of our clients in our communities that face over-policing, and if they get stopped, they could be put through the system and lose, their cars could get towed, they could lose housing, there's all kinds of collateral consequences that stem from an arrest from these old warrants.
About the fact that they didn't show and the consequence of their I think they will breathe a sigh of relief that this has been resolved. But I also think that this reflects that the law doesn't do this easily. I mean, this has taken a lot of effort by the court system, as well as the parties, to actually sort of do something that is off script, but actually serves the interests of justice enormously. And I think marijuana legislation that changes the laws, which I think is ultimately going to take place in New York, should be looked at hard now, so that we can get ready for that day. And I think that day is coming for legalization of marijuana, and that all the parties who are going to be impacted if that happens, police, communities, licensing agencies, the state government, can get started and look at the experiences of other states to make sure that New York State, if it does go that route, and I hope it does it in the best way possible. There are times in my administration of an agency for which I'm responsible and how we allocate is because when you look at the cohort of individuals who are charged with marijuana offenses, as we did for 2017, of the I think 5,000 cases that we prosecuted in 2017, only about 200 of those individuals had a prior violent felony conviction. So this is not a cohort that actually has a history of being violent. So that led to our policy decision today that we would not charge someone today with possession of marijuana, smoking or non-smoking, unless that individual either was seen selling, but we couldn't make a selling case because perhaps the buyer ran away, or there was an active, live, current public safety necessity to do so.